Good afternoon. This is Sean Golding with Golding and Golding, here to focus specifically on what happens when you receive a CP15 notice for late Form 3520 penalty reporting. I can't tell you the number of people who reach out to us. They've spoken to other counsel. The advice sounds absurd, or it sounds unproven, or they want to do contingency fees and collect millions of dollars off of your penalty. Let's go through the basics of how this works, okay? Form 3520 is primarily used to report a gift from a foreign person. Foreign person is not just an individual. It can also mean an entity, partnership, corporation, etc., etc. It's also used to report when you receive trust distribution, foreign trust distribution, and there's no threshold. So like when you're doing gifts from individuals, it has to be more than $100,000, related party rules, etc., etc. If it's from a foreign entity, it hovers around 16,000, I think 688 or something along those lines. Those are for entities, and then for foreign trust, there's nothing. There's no threshold. So if you get any foreign trust distribution, then you have to report that. The reason why the Form 3520 is so obnoxious is because of the penalties, right? I mean, oftentimes someone has no unreported income. You know, Jim might have received a gift from his grandma in Peru, did some Google research, you don't get taxed on a gift from your sweet grandma from Peru, so why do you think any more about it? And then you learn you're supposed to do 3520, file it, and you end up getting a 25% penalty if it's more than 5 months late. It's 5% a month, up to 25% on the value of the gift. So maybe it's an inheritance, right? An $800,000 inheritance, and you end up paying $200,000 in fines, which is absurd, right? On a side note, if you're looking up 3520s, you may also use the 3520 for foreign trust. We're not really talking about that today, but when it comes to foreign trust, there's 3520 and 3520-A. The penalty varies based on whether it's for the owner or the beneficiary. There was a recent case, Wilson, not a good case for taxpayers at the appellate level, which basically said, hey, if you're the owner and the beneficiary, then you can get dinged twice. But for this, we're really just focusing on gifts. So normally what will happen is you filed your late 3520, maybe with a reasonable cause letter. And oftentimes when you do it, if it's done correct and the reasonable cause statement is sufficient, you'll get no penalty. You'll never hear from them again. It used to be better back in the day before they changed the delinquency procedures. Now penalties are being issued a little bit more. Hopefully that will change. But you submit the 3520 CPA or whatnot, you're turning, you forget about it, life's great. 1 to 2 years later, you get this notice in the mail that says, hey, you owe $200,000 penalty on an $800,000 gift. You either get it on a CP15, which is more common, or you might get it on an 843 letter, which basically means you submitted the reasonable cause initially, it was rejected, they're not giving you another bite at the protest. When you get the CP15, you have 30 days to protest it. You have to show reasonable cause and not willful neglect. The idea is to put your best foot forward, maybe not putting everything in there because you don't want a 20-page dissertation because they're not going to read it because the guy or gal at the IRS is not getting paid to do that. So you want to make it succinct, you want to make it persuasive, and you want to put your best foot forward. Now, it may take another 6 months to a year or two to hear back from them. They're way overworked, they're understaffed. So just because you haven't heard back doesn't mean that they haven't received it. So typically you'll send it some type of certified mail or whatnot. Okay. Let's go through a little bit of fact versus fiction. You know, someone will reach out and say, hey, I heard that reasonable cause never works. Well, that's a lie. In fact, oftentimes reasonable cause can work. It depends on the facts and circumstances. If someone's getting a whole bunch of gifts, high dollar gifts, and there's really no basis for it, just maybe family, friends, they have extra money and they're giving it to you, well, that's swell. But, you know, versus if it's an inheritance, if it's maybe it's a gift for someone who just got off F1 as a student, you know, it's really based on the facts and circumstances. So, you know, be careful of attorneys that are going to try to, they want, you know, $50,000 in hourly fees from you so they can, you know, put together a reasonable cause letter that they're telling you it's not going to work, because it can work, but it doesn't always work, even if you have reasonable cause. It's important to use the reasonable cause letter to set yourself up for the future. Another common misconception is that if your protest letter is rejected, you have to do collection due process. Here's the problem with that. You have an appeal. So when you do that, you get the CP15 and you protest it, and it gets rejected. Even if you have the best facts in the world, the IRS agent wasn't feeling it that day. Maybe he or she's never received a gift that big. So, they don't think you have reasonable cause. So what happens is you can immediately appeal, right? You have 60 days. Or you can wait and do a collection due process hearing down the line. Now, when it comes to an appeal, there is no absolute certainty that if you do the appeal, you can't do the collection due process. But at the end of the day, the IRS can take the position you had your bite at the apple with the appeal, so you can't do the CDB. So the collection due process, you get to go before a settlement officer instead of an appeals officer, which can be a benefit. But a problem is it's an end game. You have to wait until you either got a notice of intent to levy or an actual notice of federal tax lien placed on you. That may not vibe with what you're going for, right? Maybe you're looking to buy a house. Maybe you're looking to get a mortgage. Maybe you're worrying about your credit report. Whatever it is, you may not want the world on notice that the IRS says you owe, close to $250,000 in penalties. So before just assuming that you can't do an appeal that won't work for you, you should really make sure that you're working with counsel that will go through the different options with you, because appeals can be successful. We've been successful. I know other firms that have been successful. So it's really just a matter of what works best for you. Another strategy some attorneys are putting out there is that the 6751 and FOIA. So what happens is essentially Freedom of Information Act request. So essentially what happens is in order to issue penalties, it has to receive written supervisory approval from the immediate supervisor, right? So, you want to think about putting that argument out there. But in actuality, there's an exception if it's electronically assessed. I don't have the exact verbiage on it, but if it's electronically calculated, then essentially you don't have to get the immediate supervisor's approval. And these are the types of penalties, 3520, that are oftentimes electronically calculated. Why? It's just the value of the gift and the number of months it's late up to 5%. So in order to get to the 6751, you typically have to go through the FOIA, Freedom of Information Act. They don't have to give it to you. They can make it difficult. And then if you lose that because, hey, now the top paper on your file just says, hey, we followed procedures, and that may not help your case. So something else to be aware of. It's a total strategy, right? The reason some of these people put it out there is because they want to collect a grip of attorney's fees. And so it's something to be cognizant of. Finally, contingency fees, just be careful. Let's say you've got $1 million penalty and you're going to pay someone a 30% collection fee if they get it reduced down to zero, which might have been done for $5,000, $10,000, $15,000, but instead now you're paying someone $300,000 in attorney's fees. So just be aware. It sounds good up front, but you got to be careful of the different strategies. If you miss filing the 3520, typically you could do delinquency procedures. The rules have changed a little bit since November of 2020. If you have other issues like FBAR and FATCA, you may want to consider doing voluntary disclosure program if you're willful, or just can't certify under penalty of perjury that you're non-willful. Otherwise, you have the streamlined procedures, delinquency procedures, and reasonable cause. We have a lot of information available on our main website and our sub websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.